On this episode, we're talking about something many people put off, but everyone needs, and that's estate planning. Whether you're building wealth, running a business, investing in property, or simply want to make life easier for the people you love, having a clear estate plan is critical. In our business of creating lasting wealth through property, it's one of the most common topics that comes up throughout an investor's journey. They've worked hard to build something and want to know how to protect it, not just now, but long after they're gone. This conversation came from a great question we received from a listener. We've managed to build a decent portfolio and know times are getting tougher for the younger generations to do the same. How can I make sure everything we've worked hard for continues to grow and provide for our family for years to come? Here to unpack it with me is Jemma Sanderson. She's Head of Self-Managed Superannuation Funds and Succession at Cooper Partners Financial Services. Gemma has over 25 years' experience providing strategic advice on self-managed super funds, estate planning, and wealth management to clients. Let's get into it, Gemma. Welcome.
Thanks for having me, Damian. I can't wait to unpack a little bit more about what we're talking about today.
Now, estate planning, a lot of people don't really want to think about it or talk about it because often that means that they've passed on to the next world. But how do you describe estate planning to clients, and what often people think it is?
So estate planning, a lot of people think is just a will, and it is one of those things where people don't like to think about it, but unfortunately it's one of those, knowns in life, death and taxes. So it's really important that people are looking at not just, do I have a will and what does that contain, but there's a lot more to consider. And it's also about control of assets and entities. So if someone has a family trust or a self-managed super fund or a private company, those might not actually form part of their will. And so the control and succession of that is important, and not just when someone dies, but when someone doesn't die and might be incapacitated. So it's really important to consider that more widely.
Yeah, it's a very complex area, but obviously experts like yourself help our clients through it. So if you're sitting down with a client, the will is obviously an important part in their personal name, but how do you decide what the right way to go about it is in terms of, do you map out their group structure? How do you go about that?
So that's probably the starting point, is looking at their group structure. And one of the important things is what they might think happens to assets and control, and what actually happens to assets and control when you read through trust deeds and who the owners of underlying assets are, can be quite different. And also a lot of people, they might have put a will in place many, many years ago, especially when their children were perhaps born, and it's just been sitting there in the drawer and not having to be used. And then they've built up this wealth over time in different entities. So all of a sudden, it's good they've got a will, but it's no longer potentially fit for purpose, and that includes from a tax perspective as well as asset protection perspective.
So I want to get through the different structures and how that those assets get passed upon your death, and about control as well. So let's start with the super fund. So self-managed super fund, or even just super generally, people think, well, what happens to that when you die? And then maybe explain if you've got a binding death nomination, what that is and how that influences your superannuation, where that goes to regardless of what it says in your will.
So superannuation from an estate perspective there's quite a lot to unpack. So one of the elements that a lot of people look at is, do I have a binding death benefit nomination? What does that mean? There's only certain beneficiaries that are eligible to receive a payment from superannuation when someone dies. So that's the spouse, children of any age, the estate of the individual, or someone who might be what's called a dependent. So you've got to fall within those criteria. Then you could have a binding death benefit nomination, and that by it being binding, that means the trustee has to abide by it. So a lot of people have those in place. What we encounter particularly in self-managed super funds is, again, someone thinks they have a binding nomination but it hasn't been executed properly in accordance with the deed, or various other considerations like the nomination of ineligible beneficiaries. So that's one element for people to think about. The other thing is, if they have pension accounts in superannuation, doesn't have to be self-managed but can be non-self-managed, is if they've set those pensions up to be what's called reversionary. So if the person has an eligible reversionary beneficiary, which is mostly the spouse, then that spouse can continue to receive that pension account. So even though the person dies, that pension continues to be paid to the spouse. So they're just two of the considerations there. Then the other thing, there's lots of tax provisions that you have to overlay with this. And so there's limits on how much the survivor can keep in superannuation, where their partner might die, and then the balance would have to come out of super as a lump sum payment. Then there's different tax outcomes for that. So it depends is the correct answer to your question, but I could talk about an answer to that question for about 30 minutes.
Yes, I know it's a passionate area for you. So binding death nomination generally, unless the super fund specifies something different, I assume, but you tell me, is how long is that valid for?
So unhelpfully, again, it depends. Within self-managed super fund land, they can be what's called non-lapsing. So you can put one in place now and it won't lapse after a period of time, but that's very dependent on the trust deed for that particular fund. There was a High Court case that confirmed that position, so we like nerding it up from that perspective and reading through those. In a non-SMSF, the consideration is about what the deed says. So most non-SMSFs have to have a 3-year life attached to them. So that's an important consideration in terms of refreshing those, because 3 years goes by in the blink of an eye. Some of those larger funds do offer a non-lapsing binding death benefit nomination, and that requires trustee sign-off. So effectively it's a contract between the trustee of that larger fund and the individual and their estate effectively to sign off on that.
And that's really important, isn't it? So if you're, let's say you were looking to leave your superannuation to your spouse, but in your will you might have said, well, my spouse is going to get my super in the house, so in my will I'm just going to leave it whatever's left to the kids. But if there's no binding death nomination, does that mean then that the estate gets the superannuation, and that means it goes to the kids straight away before the spouse gets that opportunity? So
again, unhelpfully, it depends, and mostly it comes down to what the trust deed for the fund basically stipulates. Most SMSFs and the larger funds, if there isn't a binding death benefit nomination in place, it'll go down to trustee discretion, and there's quite a process involved in terms of determining that trustee has to put their trustee hat on. So they can't, if they're also an eligible beneficiary, for example, the spouse, they can't just say, oh, well, I'll just take it all myself. That might end up being the outcome, but there is a process that they have to go through, and there's been quite a bit of litigation in that area. So again, another reason to look at things really more critically and be thinking, should I have a binding death benefit nomination in place to avoid any of that contentiousness in the future for the family?
Yeah, I'm sure nobody wants to leave a mess when they pass on, and particularly have their children fighting over the money.
That's right.
And often there's second marriages or second partnerships, and that may well mean that it gets more complex, doesn't it?
The other thing is, again, if you don't map out where assets actually currently pass, and they might end up, the control of particular structures might end up in the hands of the person that is unintended. So it's really important to be mapping out, again, not just where the asset you think is going, but who's in control of those structures, because that can be the difference between someone inheriting their fair share or zero.
So the superannuation can go separate with a binding death nomination regardless of what the will says. And the other asset, of course, is a property in joint tenancy. Do you want to just explain what happens on death in a joint tenancy, which not all, but most couples own their property that way?
Yes, they do. So again, that joint tenancy. So there's two different ways that you can, again, I'll refer to couples. It might be a 50-50 interest, but you can own your family home either as joint tenants or as what's called tenants in common. So as joint tenants, where one of the members of the couple dies, then that property, their 50% share of the deceased automatically goes to the survivor by what's called the laws of survivorship. So that's where it's joint tenants. If it's tenants in common, both parties have a distinct 50% share in the property. So if one of the members of that couple dies, their 50% share is then subject to their will. So if their will says, on the basis someone might be thinking, oh, well, my spouse gets the property, I'll leave everything else to the kids. The kids might end up inheriting that share of the property. And so if you don't have a look at that in more critically, then that could be the outcome.
Yeah, and they might decide that for the surviving spouse, they want their money sooner. You think it doesn't happen, but it unfortunately does, doesn't it, Pooh? Where there's wills and money involved, families can sometimes fracture.
They can certainly fracture, and if there isn't that forward planning, it can be almost diabolical and irretrievable for family members in terms of their relationships and things like that.
So what happens generally if someone doesn't have a will, they assume around the country, obviously it will vary state by state, but does generally then the public trustee take over the management of that assets?
Not usually. What needs to happen is, instead of someone applying for probate when there is a will, they apply for, in Western Australia, what's called letters of administration, and they then become the administrator of the estate, and they have to distribute the assets in accordance with a formula. And the formula for when you die intestate in WA is that the spouse receives up to, depending on whether there's children. So if there's no children, it's about $800,000 of the first amount, up to 800 odd thousand. It's about closer to 820,000. If there are children, it's closer to 550,000. They get the first amount of that, and then the balance is distributed again in accordance with a formula based on whether there are children or not, siblings, parents, etc. So it's not diabolical for the spouse. However, what is often encountered is in the situation that, say, one spouse owns the property or the home because perhaps they bought it before they had partnered with that person, and then they don't have a valid will, and then the spouse is thinking, well, it's our family home, I've contributed to paying off the mortgage, and then they only get a proportion of that as an entitlement, and the balance then goes to the children. And so that can be a tough pill to swallow, especially if there's still a debt attached to it that the spouse or the survivor is paying off, but the kids have got an ownership interest in that property.
And people maybe don't think that through. There certainly was a famous entrepreneur in Western Australia, Robert Holmes à Court. Many of the listeners may not remember back that far. Famously had, I think, made $1 billion, didn't have a will, and then that went through the whole process exactly as you said. And it wasn't just 800,000 at stake; it was a lot more. And if the family's intact, that probably still works out. But if the family's not intact and the kids get it, then you might not want it to go to your kids. Then you might want it to go to your spouse first of all, then give it to the kids. But kids can start having a claim. Well,
that's right. And back then, those thresholds, so at the moment about the 550 or 820,000, those are really quite new. That was only introduced in 2022. So prior to then, it was something like 75,000. So which in current terms is almost nothing. And if you think about the scale of the Holmes à Court estate, my understanding is that took 25 years plus to actually be dealt with because just of the level of assets all over the place, valuing them all and all sorts of things like that. Like, again, that can be a real challenge and mean that any estate takes a long time to deal with because you've got to get valuations for assets, figure out, again, who's entitled to what, who's in control of what it might be. And then you've got some underlying tax considerations as part of it all as well.
Yeah. So let's say someone does get a will and generally if it's, the estate may not be that necessarily big for someone who's got a home, they've got a spouse and they've got a joint tenants, they've got the superannuation with a binding death nomination, they've got a bank account, and that's generally not that much, but of course the second partner will eventually go, sadly, as we all know. Yeah. And then if that partner doesn't have a will, then you're in the same boat, I gather, if you don't, because how it goes to the kids.
That's right. So if one person has a will, well, they've got a will, so that's great in terms of the people who their beneficiaries are, because they'll know what to do in accordance with that will. And if everything goes to the spouse, they might not die with many assets in their own name. So as you said, if it was a joint tenancy, that automatically goes to the spouse, which means that it doesn't form part of the will. If there's a binding death benefit nomination or a reversionary pension, that pays it automatically to the spouse, and that could go completely, again, it circumvents the will. So it might be that the person dies with a nice watch, a car and, a bank account. And so there's not a lot that is governed by their will. So then the beneficiary has inherited everything, and then they need to make sure that everything's covered from their perspective.
Even more complex. Now, this is just a simple estate there where we're talking about, and which most people have a house, a super and a bit of bank account. Still definitely need wills, 100%.
Yes, correct.
But of course then, you mentioned earlier on, control of assets, and particularly if you've been a business owner or entrepreneur and bought a lot of assets outside in other structures, that's a completely different story. You can't give powers necessarily and assets in those other structures through the will, can you?
That's right. So sometimes it depends on how money might have been initially input into some of those entities. So if it was a loan to a discretionary trust, as an example, that might be on the individual's personal balance sheet, which would then form part of their estate and therefore will. But if it's been a successful business that has distributed profits out every year, or that discretionary trust owns shares in what we call bucket companies, and that's just been distributing down to that company, and that company's been investing the money. So it's all that wealth is sitting inside a structure, and people might be thinking, oh, well, I'm worth, $5 million because I've got like my property investments in my trust or my company, but they're actually not worth that at all when it comes to their personal balance sheet. They just control those assets. So within a company, there's shareholders, and if the shareholder is an individual, then that asset would form part of their estate. But if the shareholder is a trust, then it comes through to looking at, well, who's in control of that trust? The trust itself might have its own assets, property, so capital gains tax assets, subject to the government deciding to change their mind on how capital gains tax discounts work. Again, a trust is a good asset structure for that, and so a lot of capital assets are held in trust. So I would expect to see a lot of your clients would have a lot of property sitting in a discretionary trust, and the control of a discretionary trust comes down to who the appointor of that trust is. And if someone dies, I would expect to see the deed would say who's coming down the line next, and have that cascade in there. But sometimes it doesn't. Yeah. Sometimes it says, or per the will, so then you are going to the will to see who might be involved. But often if it lists who is taking over, then the will is irrelevant.
And so in that scenario, as you mentioned there, but people think they're worth a lot of money, but technically if it's all in family trust beside your home and that's going to your spouse, your estate's got pretty much nothing else.
That's right.
So the important part of a family trust is the control point. And we won't go into a lot of detail about appointor because that's, and the guardians and all those roles, because that's where you need to go and seek advice. But so trustee might be a company, but so the share ownership of that company who's the trustee, is that important, or is it really just the appointor that's the most important role?
So it can still be important if you're the shareholder of that corporate trustee. However, if the appointor is someone different who maybe inherit the shares in that corporate trustee, then the appointor can still sort of swoop in and appoint someone else or another corporate into that role. But it does depend, again, back onto the trust deed and what the trust deed says. Mostly the appointor has that overarching controlling element, but there have been a few cases recently where the trustee could make that decision and basically outvote the appointer. So again, a lot of lawyers will say, read the deed, read the deed, read the deed. And again, that's no different across the board. So
in a scenario where the first partner's gone, then the second partner is alive, and they want to leave the ability to be appointor to. They've got 2 children, and they think I'll give it to the oldest one, and but then technically the oldest child takes it. Maybe they don't like their younger sibling, which is not uncommon. Can they then just say, I'm going to take all the assets and use them for my benefit and not necessarily give them to my sibling?
Well, that is a potential risk, absolutely. And so the estate itself, or the will, so say dad's already died and mum's taken it over, and then there might be a loan there that's still on mum's balance sheet, so that element. But if any net value of those assets, so if they've gone up in value since being acquired, yeah, absolutely, you've got that if one child is taking over that particular trust from that control perspective. But sometimes that is actually a good estate planning strategy. So you might have multiple trusts and think, right, well, I'll channel that one to that child. They'll be the sole appointor to take over this asset or group of assets to the other child, and that can be part of a strategy. And even setting up, we try not to set up too many entities along the way, but particularly for property, people can do that from a land tax perspective. So you could have multiple trusts sitting there in place with different assets, and it's important that if you are going to channel those to different people, that if you want to treat everybody in a fair manner, then making sure that you're covering off on that with an equalisation clause in a will, and and again, that only works if there's assets in the estate too.
Yeah.
So,
and you can you could appoint them as joint appointors, or a company that they get the shares in equally, and that will help balance out those if you didn't want to give one trust to each one. The other thing I want to talk about is testamentary trusts.
Yes.
There's been some articles in the financial press recently about those, and particularly got that great wealth transfer as the baby boomers move on to the next world. Yes. And that there's going to be, I think, $5 trillion of wealth transfer. So it's
a lot.
It's a lot, isn't it? And so more and more people are starting to use testamentary trusts. So again, that is only assets that they have in their own name that they can transfer. And it's not the family trust, it's just about control. The assets you have in your name, you can put in a testamentary trust. Do you want to explain, Jenny, how people set up these testamentary trusts?
Right. So a testamentary trust can only be set up by a will. So you can't just right now go, oh, I'll just set up a testamentary trust. So the name testamentary is because a testator has died. So it has to be drafted into a will. So some people think, oh, well, there's a will there, Dad died, there's a will, we'll just set up a testamentary trust. Unless Dad's will specifically provides for a testamentary trust, you can't really set one up. There are circumstances where you can, but it's very, very limited. And so it's important that you're drafting that testamentary trust into the will. And then a testamentary trust operates very similarly to a normal discretionary trust, in that you have an appointor, there's a trustee, there's beneficiaries, all of those things going on. And so assets then form part of that testamentary trust from the will. Now, one of the big benefits of a testamentary trust is the ability to distribute to minor beneficiaries. So I'll call them the little E's, the under 18s, the grandkids or great grandkids at adult tax rates, which you can't get in a normal discretionary trust. That's a big winner. A lot of people are like, oh, fantastic. And then that can help pay for school fees and the like. From my perspective, my main priority or preference with a testamentary trust is the asset protection that it allows, because if you draft the testamentary trust provisions get drafted correctly into the will, you can really be quite robust and put a nice big asset protection wrapper around that, so that the individual, so say it's the children, might all be inheriting. You're trying to protect it from family law risk or other creditor risk. And it might be not at that generation, but the next generation, protect from those rogue Kens and Barbies coming through the mix.
Yeah, who you can exclude spouses from the testamentary trust. So technically that's not an asset that is owned by that child. So let's say you had a $10 million estate, you gave it equally to your two children, $5 million, it went into a testamentary trust. As you said, Ken and Barbie, a couple of years later, if they've been with them, and say, I want some of that. And but if it's a testamentary trust, the argument can be, well, that's not an asset that's technically mine because there's got appointors and trustees. That's
right, and there has been some precedent for that, where if the structure of the testamentary trust, again, has that robustness around it, then it can be, instead of it being treated as a financial asset for family law purposes, it's a resource and it's not available to be sort of busted apart by I'll call them a rogue Ken or Barbie, yeah.
And again, if you've got two kids or a couple of kids and one is very wise with their money, but one you're not so sure, that you think that they're $5 million, they'll go and buy Ferraris. And a testamentary trust, you can have maybe a trusted relative who's the co-trustee and a potentially co-appointor, that they can be then help that person manage their money so they don't just get it all in one big bucket.
That's right, and especially if the children are a bit younger, and some people think, oh, what's the ideal age? Is it 18 where they take control of their trusts? And maybe I'm a bit unkind, but it's like 35 these days, where you think, okay, now I'm comfortable for the kids to sort of take over, and you put that trusted friend or relative in there either with them or instead of them until they get to that point. And especially if there are some at-risk beneficiaries, so they might be vulnerable or not really that financially literate, having that extra person in there just gives that extra layer of protection. But you do have to be careful, because if you're leaving assets, you want to leave it to your beneficiaries and you're trying to protect them from themselves, potentially. But then there's been cases where, because if you are a potential beneficiary and you haven't been what's called adequately provided for, you can dispute the will. And so if there's a trust there that might be locked down to some element, then that person has the ability to sort of say, well, I haven't been adequately provided for because I don't have access to the dough straight away, basically.
Now, there's certainly, as you mentioned, a lot of litigation in this area. And I think with 5 trillion passing from one generation to another, we're going to see more and more of it. Isn't it about half the people don't have wills? Is that the right stat? Or how many percentage of people don't have wills?
Oh, I'm not actually 100% certain, to be honest, but I think it's more than what people would expect. And really, once you get to 18, you should have a will, even if you don't have any assets. You know, an 18-year-old might just own their car and that's pretty much it. But it's really important that they have a will, and at least then they've appointed someone who's then the executor and can step into things. And the other thing with now that superannuation contributions are becoming more compulsory for a lot of people, unbeknownst to them, they might have a superannuation pot there that's worth, you know, it could only be tens of thousands of dollars, but with some automatic insurance in there, all of a sudden it's a few $100,000 that needs to be dealt with, and then you need that will to determine where that's going.
Yeah, thanks, Gemma. I mean, it's a very complex area. I think the message today is hopefully it gave people some broader understanding, but particularly if you've got, everybody should have a will.
Correct.
But particularly if you've got business in different structures, you've got to think it through and regularly get that reviewed. How often should someone reassess their circumstances?
So if there's a big change, so they get married, well, marriage voids a will anyway, so they need to have a look at that, as does divorce. So those sorts of big life moments. Having children is worthwhile, even buying new assets, especially if it's the family home and they've put it in joint names, or it's only in the name of one of the spouses for asset protection purposes. It's really important that the will is looked at then. If you're buying assets in entities, and again, your succession needs to be looked at. And the other thing is it's, yes, we've talked a lot about death, but it's also incapacity. And with that, all the baby boomers coming through, the rates of dementia and those sorts of things are also increasing. And so it's really important that people have thought about not only what happens when I die, but who's in control when I'm incapacitated. And the family needs to be aware of what that looks like as well. So with the power of guardianship, if you don't have one, it reverts to the next of kin, but they might then be the ones who make decisions about end of life care. So there is another document called an advance health directive, and that's where the individual can sit there and decide how they want to be treated at the end of their life. And that's quite an important document for them to consider as well.
The Advanced Health Directive, what sort of legal status does that have versus just someone who's got the enduring power of guardianship?
So the Advanced Health Directive, if it's again been signed and witnessed, then really that's the decision that has been made by that person, and so all the health providers would abide by that. So if the person who holds the power of guardianship, they have a different view, then the Advanced Health Directive would be what stands. A lot of people indicate that if they've nominated people to be their guardians, they accept that they will make the right decisions. But I always tell people that they should have an advanced health directive as well, because they've then made the decision, and say the children are then the ones who are saying, well, that's what mum wanted or that's what dad wanted. They wanted to die with dignity, so let's, do not resuscitate sort of consideration, as opposed to them having to make that decision. So the decision has been made and they're implementing it.
You think your kids might turn off the machines too quickly? You get one of those. Really complex area, but also I think it's important that maybe we just talk about letters of wishes. Now, that's not legally binding, but that's becoming more common, isn't it? Where particularly in more complex structures, people go, this is what I really want. You would hope it's got moral authority, even if it doesn't necessarily have legal authority.
That's right. And it also, I view a letter of wishes or a memorandum of wishes as a bit of an instruction manual. So you've got the will, and that deals with your estate assets. You might have the super fund, and that's got a binding death benefit nomination or a reversionary pension or a deed that would govern what's happening there. The different discretionary trusts that you might have got different control mechanisms. So the letter of wishes brings it all in together and goes through what the intentions also are. So I've left the appointorship of that trust to Jimmy so that he can benefit from that and his family can benefit from that asset. Or I'd like an equalisation to happen, or any other things about the management of the assets going forward as well. So there's a lot that can be captured in that, and we consider it a really, really important document to, again, bring it all in together. And a will is very legalese, as are trust deeds, whereas a letter of wishes is designed to be a bit more layperson, so that someone can pick it up, read it and say, okay, I get it. I understand why that company is there. why that person is become the director and who's getting what in the scheme of it all. And the other element of that is people think about like a testamentary trust. So from what we've spoken about, I'm sure a lot of people are like, oh great, the tax concessions and the asset protection. But if you just leave that in your will and you haven't explained it to the family, then they're like, oh, I don't want to manage a trust, get rid of it, but then they're missing out on the potential benefits. So we also find it really important to sit down with the family and go through it all and answer any of their questions. And then that awareness, they might not remember it, but they've at least had that conversation and may well have been involved in some of that decision making, and it really just avoids any issues in the future as well.
Thanks, Gemma, for your great insights. Lots to unpack there. The moral of the story is go and get a will, go and seek advice.
Absolutely.
Estate planning isn't about being pessimistic or planning for the worst. It's about being proactive and protecting what you've worked hard to build and giving certainty to the people you care most about. A key takeaway from today's episode is that a one-size-fits-all approach doesn't work. Your family, assets and goals are unique, and your estate plan should reflect that. And just as importantly, it's not something you set and forget. It needs to be reviewed as your life changes. If today's discussion raised questions or made you realise your estate plan might be outdated, that's a great first step. Getting the right advice now can save your family a lot of stress, conflict and expense later. It can also ensure your wealth continues to provide once you're gone.